Hi there, this is Jack Duffley with Duffley Law. Let's talk about the basics of probate. First question, what is probate? Probate is the legal process where the court determines where assets should go after someone passes away. And when I say assets, I mean things like real estate, houses, vehicles, property, pretty much anything of value that the person leaves behind. And the main purpose of probate is to, quote, settle the estate. So we're trying to make sure that any debts outstanding are settled and that the assets go to the right people. Probate also gives people a chance to dispute others' claims to that property. The first step is to figure out whether there's a will involved. If someone left a will behind, that's going to generally guide the probate process if it's done properly, of course. If the will was done improperly, or if there is no will, then that would mean the person died what we call intestate. That's where someone dies without a will, or the will is otherwise invalid and wouldn't apply to the probate proceeding. But if there is a will, it's typically going to name someone called an executor. And that executor is the person who is generally in charge of running the probate process along with the court. The next step would typically be to file an application for probate with the court along with the will, or if there isn't a will, then there won't be one included, and it might change the papers a bit. But the process is very similar. We're applying for probate and then trying to name an executor or an administrator to manage the process. After that, some sort of notice is typically given to give other parties a chance to make a claim on the estate, or if any parties weren't named in the initial application, it's sort of a window for anyone to come forward just in case they were left out when they maybe shouldn't have been. But once that's done, it's time to determine where all the assets are and which assets are left behind. Sometimes a will name what all the assets are, and that can make it very helpful for going through this quickly. Sometimes the will leave things very open-ended, and there might be property that people didn't know about, and that's discovered during the probate process. So that can take quite some time depending on how big the estate is and how much was known about the estate before someone passed away. The same goes for figuring out any debts or liabilities that the estate might have had. Once we have a clear picture of what's in the estate, the court will determine where those assets should go and who should get paid at the end of the day. But if there isn't a will, then it would fall to the rules of intestacy, and each state has its own standard for determining where things go. If someone dies without a will, it's usually a pretty long list of situations that it lays out. If someone died with a spouse, if they didn't have a spouse, if they remarried, if they had kids, and all that sort of thing. But at the end of the probate process, the court will give its approval to the executor or the administrator of that estate to then carry out the court's order and make sure that those things get to the parties where it's supposed to go. And that's pretty much the whole probate process. Now, that process can take a while. Often we're talking about at least a few months, if not over a year in very complicated cases, or in cases where there are a lot of people who are making claims to the estate. Those claims have to be addressed. That all takes time, and it can really stretch out the time it takes to finish a probate case when that happens. Now, not all assets are subject to probate. There are certain strategies that people can use to try and avoid probate for certain assets. For example, using something like a trust in many cases will avoid probate, at least for the assets that are in that trust. We set this up for our clients all the time on the estate planning side of things. But very generally speaking, any assets in a person's name when they pass away are subject to probate. Again, it's not every single case, and there are exceptions, but that's kind of the general rule. In some cases, there's an expedited or alternative probate process to get an estate settled, and that could be something like a small estate affidavit or a minimum of title for real estate. There are some other options out there, but they're very specific in how they can be applied. But at the end of the day, they're all trying to do pretty much the same thing. It's a court process to determine what assets and debts are there, and then trying to figure out where those assets should go after someone passes away. Probate can be a very difficult process, and unfortunately, it's often coming at a time that's already difficult enough for the family that might be involved. Someone just passed away in many cases, and there's plenty to worry about there, and now probate is just an extra thing on top of that. Whatever the case, if you're considering starting a probate action, if you're not sure you need to, or if you're sure you need to because you're an executor or something like that, then definitely make sure that you get professional guidance to figure out what the next steps are. It can be very easy to take a misstep, and that can cause problems down the line, and we just want to make sure that things are done properly. And the whole point of probate is to settle the estate so that anyone involved can move on after it's done, knowing that things went to the right party. If you found this video helpful, then definitely subscribe. Otherwise, I'll see you in the next one.